Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Interpretation class. So we had a brief introduction regarding the interpretation of the statutes. Now let us know the first rule of the general principle of interpretation, out of which I am telling you the literal rule of interpretation, liberal rule of interpretation, grammatical rule of interpretation. All the three convey the same meaning. Literal interpretation. So it clearly shows when the words are clear, when the words literal meaning is not ambiguous. So the words should be given their ordinary meaning. The word should be given their natural meaning. So you should not extend them. So here I want to caution you before I start my video. Please remember, if the words are clear, you cannot interpret. ఉన్నదానికి ఇంటర్ప్రిటేషన్ అక్కర్లేదు. తెలియకపోతే అంబిగ్యూస్గా ఉంటే లేదా కన్ఫ్యూజన్గా ఉంటే మీరు ఇంటర్ప్రిట్ చేసుకోవాలి, కానీ క్లియర్గా ఉన్నదానికి ఇంటర్ప్రిటేషన్ చేయకూడదు. దెర్ ఈజ్ నో నెసెసిటీ ఫర్ ఇంటర్ప్రిటేషన్. దిస్ యూ హ్యావ్ టు నో. When interpretation comes, when the words are ambiguous, when the sentences are not clear, when the words are giving different meanings with their association with their meanings. So when the act itself is ambiguous, not clear, in such cases only, the interpretation will be necessary. Right? So now we are going to discuss a couple of cases where the literal interpretation was used. They are all landmark cases. Ramavatar versus Assistant Sales Tax Officer, 1961, Ramavatar, Bihar. So here the important question is whether betel leaves are subjected to sales tax or not. The contention is betel leaves, what for they are used? They are used in the manufacturing of chilies, is it not? So they are almost green vegetables, green leaves. So వాటికి కూడా సేల్స్ ట్యాక్స్ వేయాలా? సో సేల్స్ ట్యాక్స్, ప్లీజ్ రిమెంబర్ దిస్ ఎట్ ద టైమ్ బీహార్ వాజ్ ఆల్సో ఇన్ యూపీ 1961. ఓకే, బీహార్ ఈజ్ సెపరేటెడ్ ఐ థింక్. సో వెదర్ betel leaves are subject. So vegetables can be considered as those only which are grown in the kitchen garden. Betel leaves, they are being exported to some other places for commercial purpose. Therefore, definitely sales tax can be imposed. You cannot go by the word vegetable means all the vegetable colors, green colored vegetables, they are exempt from the sales tax. The words are very clear. It is a commercial purpose. Definitely commercial tax can be imposed. Second, this is Motepuri Jamindar Private Limited versus State of Bihar, 1962. Here another point, whether sugar cane comes under green vegetables or not. You might have seen sugar cane manufacturing for jaggery, manufacturing for sugar. Of course, if it is manufactured for sugar, it is a commercial purpose. But here the sugar cane was caught by the so-called, once again, the sales tax officers, and they wanted to impose a tax, whether it is a green vegetable or not. So please remember, Bihar Sales Tax Act 1947, they clearly say that sugar cane is a commercial product. Of course, if you grow it in your kitchen, it comes to green vegetable. But if you wanted to export it, or if you wanted to carry in a taxi or tractor, definitely it is a commercial purpose. So as per section that is 1947, Bihar Sales Act 1947, so it is liable for tax. The word is very clear. There should not be any ambiguity. Third case, Bimal Chand versus Gopal Agarwal, 1981. Whether biscuit is a cooked food or not. So normally we all know you eat biscuits as snacks. You don't eat food as cook biscuits as food. Of course, when food is not available, it is a substitute. It can be used as a substitute. Here the important point is whether biscuit is a cooked food or not. So according to section 3A of the UP Sales Tax Act 1948, 2% tax can be levied on the cooked food. So Supreme Court admittedly said biscuit is not a cooked food. See how funny the cases are. Another case, ihar Antale versus R.S. Nayak, 1984. Here, Section 8, Clause 1 of the Criminal Law Amendment Act 1952. Only special judge can conduct trial of such cases. Even the Supreme Court, even though the court has got authority under Article 145 to transfer the case to any other judge, but when there is a special judge, better to give it to the special judge because the words are very clear. So likewise, so many cases will be there. These are the classic cases. So please remember these cases. You have to write the exam, is it not? So with this, I am concluding. Thank you very much.